We'll now take up consolidated case numbers 21-1761 and 22-12, Floridians Against Increased Rates, Incorporated versus Clark et al.
Good morning, and may it please the court. My name is Bradley Marshall, and together with Jordan Lukeman, we represent Florida Rising, the League of United Latin American Citizens of Florida, better known as LULAC, and the Environmental Confederation of Southwest Florida, better known as EcoSWIFT. Also with me at council's table is Chef Wright, who will be presenting argument, which we certainly agree with, on behalf of Floridians Against Increased Rates regarding the lack of statutory authority for the reserve surplus amortization mechanism and automatic tax adjustment provision. I'd like to reserve 3 minutes for rebuttal. This is an appeal of a final decision of the Florida Public Service Commission approving a settlement in FPL's petition for a base rate increase. This decision is due to be reversed for two principal reasons. First, the decision is wholly inadequate and only makes 6 findings of fact, none of which relate to the major issues presented to the Commission, explain why the settlement is in the public interest, or explain why an almost $5 billion rate increase is needed. Second, the more than doubling of Solar Together creates an undue preference for participants in violation of Florida law by paying participants bill credits from the general body of ratepayers, with the general body receiving nothing in return, just like Duke's Clean Energy Connection program currently on appeal. First, as to the adequacy of the order. The Commission, in final orders with settlement agreements, must discuss the major elements of the settlement presented for its review and explain why it was in the public interest.
Is it your position that the standard for the review and the content of an approval of a settlement agreement is and ought to be different than a regular rate-making order, rate-setting order?
Yes, Your Honor. In a traditional rate-making order, if there is no settlement, often these cases have 200 issues, and the Commission would make specific findings as to each issue, and make specific prudence findings as to each project that's part of the rate base. What we're saying is that in the settlement context, as this court has recently clarified in LULAC, that the Commission still must discuss the major issues and make findings of fact as to the major issues that were presented for review.
But you agree that it's, from your perspective, a narrowing has happened. It bears less, one might say, perhaps not on any particular decision, but it has less waterfront to cover. Is that a fair assessment of your position?
Yes, Your Honor, that is a fair assessment of our position.
Okay.
But they still must cover some of the waterfront, which they did not do here. They only made 6 findings that didn't touch on any of the major issues that were presented. So it didn't touch on the rate base. It didn't touch on the cost of service allocation. It didn't touch on the Solar Together. It didn't touch on the reserve surplus amortization mechanism, better known as RSAM. And it didn't touch on the return on equity for FPL. So
I'm sorry, could you be more specific about that? So I agree with you that if you're just kind of putting aside past practice and sort of what the court historically has tolerated and what the PSC has done, it doesn't seem like you can really justify, if the point of this whole exercise is for there to be a reasoned explanation for the decisions with, pointing out, we credited this person and we think the overall balance of factors is this or that. Like, this is way below any kind of acceptable standard. However, taking a step back from it, how would you, if we were going to try to understand what the how we identify, what needs to be explained or what, who gets to decide what the major components, is that defined by what's contested by the non-settling parties, or with something of this magnitude, how would the PSC and the parties involved know kind of what had to be covered and what was enough?
I think it's just by looking at the record and what actually happened at the settlement hearing. What was contested on cross-examination? What were the issues that the parties were presenting in their post-hearing briefing that they're arguing back and forth on? And those were the issues that I just laid out, the major issues, the one that was that the parties spent the most time on contesting, and that FPL and the other settling parties spent the most time defending. And the Commission in their order didn't touch on them at all. And so when this court is reviewing the Commission's decision that the settlement as a whole complies with Florida law and is in the public interest, If there are no findings of fact that go towards that, that makes review essentially impossible.
Is your argument really based on findings of fact? I thought your argument on a lot of these subcomponents of the settlement had to do with that they were improper as a matter of law, that they were without authority, or that the statutory authorization wasn't there, or various arguments based on legal issues, not necessarily just the prudence of whether or not these individual factors are appropriate as determined by the PSC.
Absolutely. We have those arguments as well, that many of the mechanisms approved, such as the RSAM mechanism, are without statutory authority. Another one, for example, that we believe violates Florida law just on its face is the solar together provisions of the settlement. The settlement expanded.
So your argument, if that's true and you're attacking the legality of certain of these subcomponents, then what then is the PSC to do with that? I think they say in their order that they are that they have to view this settlement as a whole, that they should not look at this individually, and that we should not look at these individually. What's your response to that?
Well, certainly for the parts that we contend violate the law, if they violate the law, a settlement can't contract their way around legal requirements. Like, so for example, they can't create an undue preference in rates just because it's in a settlement. If there's an undue preference in rates, it violates Florida statute, and the commission did not have authority to approve the settlement, even if it's just a small component of the settlement.
So if there is a subcomponent of the settlement and it's $100 million, for example, just to pull a number out of the air, this whole thing are billions, right? So it may be a very small amount of money compared to the whole. Are we to look at that? Are we confined by looking at that as a whole, and to say that, okay, this settlement as a whole is fair and in the public interest, or is there something that we can and should legally do as to those subcomponents?
Yeah, this court should say that those subparts, if it finds that they're in violation of Florida law, are in violation of Florida law, and then remand the commission to the commission for further proceedings on that basis.
Is that in regular contract law? I think back on what Florida law is and how we handle contracts, right, or even statutes for that matter. In normal contract law, and after all, here this is a settlement, right? So does contract law come into play? If it did, we'd be looking at this to see whether it was severable or not. I mean, are there any severability components? If they are, if they're not, and should we slice a piece off that's could be saved and save the whole contract if possible, and if we couldn't, send the whole thing back. So how does any of that apply here? Does that apply at all? Does it ever apply under this type of law? Or are we just, if one small piece of it is unlawful, then is the whole thing tainted and we have to send it back?
I think contract principles could apply to possibly sever a part of the settlement if it was structured that way. This settlement does have a provision that says if one part falls, any part of it, even if it's a small part falls, the whole thing falls.
That's in there.
That's in the settlement.
Okay. There's a non-severability clause in there.
I think that would present a different question.
Well, that's what.
Yeah. Oh, sorry. Yes. If there was a severability clause, I think that would present a different question than what we have in this settlement, which is a non-severability clause. Okay. And just on the question about the $100 million, just the expansion of Solar Together alone brings it from around a $4 billion project to almost an $11 billion project. So we're not talking about a $100 million that we say is unauthorized. We're talking about billions here that we believe is contrary to Florida law. And unless there are any other questions, I'll save the remainder of my time for rebuttal. Thank you.
Good morning. May it please the Court. I am Robert Scheffel Wright. I represent Floridians Against Increased Rates, Incorporated. I would like to reserve 3 minutes of my allotted time for rebuttal. Your Honors, although FAIR's appeal is largely based on different grounds than those upon which Florida Rising and its co-parties have appealed, FAIR agrees with Florida Rising's arguments. With respect to FAIR's appeal, in approving the PSC's approval of the FPL settlement, the PSC not only exceeded its statutory authority, worse, it specifically approved provisions that specifically violate provisions of Chapter 366. The PSC statutes lack any statutory provisions or authority for the reserve surplus amortization mechanism, which I'll refer to as the RSAM, or the automatic tax adjustment provision, which I'll refer to as the ATAP. Both provisions violate express provisions of the statutes. I will focus my argument on these two points, and if I have time, I'll address our departure from the essential requirements of law argument. In summary, FAIR asks the court to reverse the PSC's order on the two statutory points that we have raised. The PSC lacks authority, and the settlement violates express provisions of Florida law. The standard of review applied by this court.
I'm sorry, just to sort of cut to the chase, what provision in Chapter 366 does the RSAM contravene?
Section 366.06 sub 1.
And how?
Section 366.06 sub 1 specifically provides that for rate-making purposes, the Commission is first to determine the investment of the utility that is honestly and prudently incurred and used and useful in providing public service, after which it is then to subtract accrued depreciation. The specific language is that calculate the value of the utility's investment, which shall be used for rate-making purposes, less accrued depreciation. That is the language in the statute.
How isn't that exactly what this is about? Isn't RSAM about giving effect to the reality that maybe the assessment of accrued depreciation at the outset didn't pan out, and perhaps because of operational efficiency, perhaps because of other considerations, the depreciation didn't materialize in the way the parties had originally thought? I mean, isn't that exactly what happened here? Isn't that exactly the kind of adjustment that the statute presumes that will be approved?
Your Honor, respectfully, the statute says less accrued depreciation. The depreciation reserve, the reserve surplus, is the amount of depreciation that customers have paid for through their rates over time that is greater than the depreciation actually experienced by the utility's assets. The statute says subtract that from the investment.
What do we do if they've overpaid, right? What do we do if it turns out that this plant that was supposed to be fully depreciated in 5 years, turns out we can make it run for 7? What do we do? Is the power company out of luck when it comes to they have to absorb that cost or that additional lost depreciation effect?
Not at all, Your Honor. There's no lost depreciation. The customers have overpaid the depreciation. There is, in the accounting, as defined in the PSC's rules, a reserve, in this instance a reserve surplus, that is to be subtracted pursuant to the statute from the utility's other investments. That then leaves a total amount of rate base to which the utility is entitled to earn a return. The PSC has addressed this very specifically in prior orders where it says this happens. The point is that we have to return the surplus to customers as quickly, preferably as quickly as possible. The utility is not out of luck at all. They get to recover the full amount of their investment over time.
I want to clarify something in your initial brief, just to make sure I understand it correctly. That when you're not saying, are you, that there's been a retirement of certain assets that continue to be depreciated instead of taking a loss on retirement and recognizing the expense at that point in time?
No, sir. We're not saying that at all. What has happened is the customers have paid a lot of money, billions of dollars, in depreciation expense payments embedded in their rates over time, coming up to the point of this case, of the case below, and they've paid more than the depreciation that's actually been experienced by the utility's assets. Those assets have longer remaining lives leading to the depreciation surplus. Customers are entitled, pursuant to the statute and pursuant to the PSC's prior orders, and we believe its rules as well, they are entitled to have that deducted from rate base, in determining the utility's rates.
Thank you.
Counsel, could I ask you just sort of a general statutory question? I think it goes a little bit to the corporate income tax adjustment situation, but 366.076 allows the PSC to make incremental rate changes prospectively. What do you think the term incremental is doing there? What does that mean?
I believe that the intent of 366.076 is to allow for subsequent adjustments where they are known and known in the record of the case, rate case at the PSC, and further that they still, regardless, that they still must comply with the provisions of 366.06 sub 2 and 366.07, which say that the PSC is to change rates upon a determination that the then existing rates that are sought to be changed are unjust, unreasonable, insufficient, excessive, unduly discriminatory, or preferential.
So the word incremental would mean something that's fixed or definite at the time it was decided.
I think incremental by itself means something that would be, really means in addition to what was approved in the initial base rate case. For example, if the utility showed in the record of the case, let's say that in 2024, it would incur X costs, that would be an incremental increase in rates. That would be known and proper, and the commission could make that determination. The ATAP or CITAP is frankly a pig in a poke. It's whatever it is you get to recover it. We think that's improper under 06 sub 2 and 07.
You're welcome to keep going, but you're into your rebuttal.
Oh, pardon?
I just said you're welcome to continue, but you're into your rebuttal time.
Oh, well, thank you. If there are no further questions, then I'll look forward to addressing the justices on rebuttal. Thank you, Your Honors.
Good morning. May it please the Court. Douglas Sunshine on behalf of the Public Service Commission. The Commission's final order should be affirmed as the Commission has the authority under Chapter 366 to approve the rate-making mechanisms in the settlement agreement. The final order adequately explains the Commission's decision, and it is supported by competent substantial evidence. The Commission, as an arm of the legislature, has been granted the authority to determine fixed rates. Section 366.06 gives the Commission the authority to approve regulatory rate mechanisms, which are accounting methods and are a part of the Commission's normal rate-making process. As acknowledged by this Court in Deltona Corp. Versus Florida PSC, a statutory grant of power or right carries with it, by implication, everything necessary to carry out the power or right and make it effectual and complete. The Commission carried out its delegated power to determine and fix fair, just, and reasonable rates, and by necessary implication, justifiably found it has the jurisdiction to approve the mechanisms and adjustments negotiated by the parties in the settlement agreement.
I'm sorry to interrupt you. Could I ask you a question about that? So did the initial petition include all of these subcomponents? I understand that there were some changes as a result of the settlement negotiations, but did the initial petition have sort of the base rate part and then all these other mechanisms that were, that made it kind of a coherent whole?
The majority. There were some aspects that were, through the negotiation of the settlement agreement, added that weren't in the initial petition.
Okay. And so if there had been no settlement agreement, the commission would have evaluated each of the components for its lawfulness, and then sort of the overall rates to see if they, were just and fair and reasonable and in the public interest.
Yes, that's right? What we call a full-blown rate case.
Okay. And then I don't understand why the existence of a settlement, a partial settlement really, of some subset of the parties. Why would that change the fundamental nature of what the commission has to do?
Well, 120 permits any proceeding to be resolved by a settlement. The commission is bound by that. The parties presented their settlement for approval. There was a formal hearing. Some
of the parties. I mean, it doesn't seem like this really fits. So the 120 framework in 12569 it says unless waived by all parties, 12057-1 applies. And then when you go to 12057, it has, all the things about a hearing, and then it says in sub 4 that you can have an informal disposition, i.e. not having a hearing if there's a stipulation, et cetera. So in this case, we do still have a hearing, and we don't really have a settlement that resolves all the parties. I mean, it seems like the more specific part of the, statement in 12569 that says unless all parties agree, you have to follow the standard. But really, even regardless of whether you treat this as a settlement or a non-settlement, it seems like the commission should have the ability to look at, something that's presented to it as a whole. So, for example, I know one of the arguments here is that, the rate mechanisms and all the other things allow it to be a 4-year proposal instead of just 2 years. And that would have been true at the outset, right? I don't understand why having some of the parties on board and essentially having an amended petition, why does that change the legal responsibility that the PSC would have in terms of looking at sort of the specific components that make up whatever this package is?
Well, when presented with the settlement, and again, it wasn't a unanimous. The appellants they objected. The commission holds a formal hearing on that approval. Should we vote up or down to approve or disapprove the settlement? The parties are permitted to participate. The appellants, they had their expert witnesses. They cross-examined FPL's witnesses. They submitted their exhibits. They made post-hearing briefs, their arguments. The commission weighs all of that to determine whether, ultimately, is it in the public interest to approve this settlement. In a full-blown rate case, they have to go through every aspect, every issue, and provide that detailed analysis. In a settlement, they look at it as a whole, and they're permitted to approve if there's competent substantial evidence to support the ultimate finding that it is in the public interest.
And how do you do that, though? So in this case, it sounds like there were, a subset of issues that, narrowed. There's still these major, disputes over, the factual basis, the legal basis, et cetera. Shouldn't the commission have to kind of give the public, and then in terms of for judicial review, give something that kind of addresses these, in some kind of detail, addresses what these disputes are? Like, for example, the solar together thing, it's mentioned in the summary of the major components of the settlement, but then when in the part of the order that justifies the decision, it's not mentioned at all. And this whole debate over whether the participants are paying the costs and whether that's, I know the PSC's staff analysis of this when it first came before the PSC, the staff said that it was unduly preferential and all that, and I understand the PSC can disagree with its own staff or whatever, but there's no explanation whatsoever for the PSC's thinking on how it got to approving this. So from a judicial review perspective and from a matter of the PSC complying with its obligations, how can the order not address the major issues that are in dispute in a way that allows us to kind of have a window into what the rational process was that led to the finding that it was in the public interest?
Well, I would submit that the commission's final order details those. It lays out all of the aspects that it found in the settlement agreement and provided the analysis that is within the final order.
But the chief is right, isn't he, that the final order doesn't talk about solar together at all, right? You concede that.
I concede that.
Okay.
But again, the parties, the signatories to the settlement agreement, they negotiated this document, and there's a give and take in that process.
But but the statutes and our case law make clear at the end of the day, the PSC has the responsibility to set the rates. You guys can independently initiate these things. You have to review this. So, the fact that some subset of the parties worked out a revised petition with the company, that just doesn't, if I were the PSC, it seems like that would be relevant to my understanding of whether it was in the public interest is, if you, as the order says, if a large, segment of the customer base or whatever thinks it's a good idea, but that doesn't change at all the fundamental obligation. The PSC can't delegate to these parties just the responsibility to decide what's in the public interest. So you still have the same obligations that you would have had in the absence of a settlement agreement.
Certainly. And in this case, though, you have the Office of Public Counsel, which represents all customers in Florida, approving the settlement and agreeing that it's in the public interest. You also, a majority of the parties signed off on the settlement agreement.
When you're looking at the public interest, I mean, is part of the legality of each of these subcomponents part of that, or is that a separate determination?
I think that is always a factor, and the appellants can put on their testimony as to how they interpret it in their post-hearing briefs as to why they feel it's a violation of whatever statute.
From reading your order, it seems like you're evaluating the settlement as a whole, not each individual component as you would as in a rate case, for prudence. And prudence to me seems like, is this a good idea or not overall, right? And whether it's in the public interest overall or not, which seems like maybe a different question as to whether each of these subcomponents are legal or not. And if one of them is illegal, or if there's some part of the settlement that's not legal, it seems like the PSC has a responsibility and certainly authority to look at those individually and say that part is not legal, it should not be included in here, and not be bound by looking at the agreement as a whole instead of individually. Would you agree with that?
Yes, I would. And the Public Service Commission they did have an incident where there was a settlement agreement, where there was an aspect, an issue in the settlement agreement that they took, that they were concerned with. They advised the parties, allowed them to caucus, and they did amend the settlement and bring it back to the commission, and then they ultimately approved it.
So if that's your review, would you agree that that should be our review as well, that we can look at these individually, and if it's wrong as a matter of law, then we should be able to reach that subcomponent instead of being bound by looking at it as a whole?
If this court finds that there is an aspect that is in contravention of a statute, illegal, I agree. The commission cannot approve such an aspect.
So then the whole thing goes back. Is that the result?
In this case, if the court deigned to remand back to the commission would take the case up. It would be up to the parties, up to FPL to determine.
I'm just talking hypothetically what the remedy is if there were a settlement and some subcomponent found by the court to be unlawful. The remedy then is to send it back to the PSC.
I would agree with that. And as indicated, it is an all or nothing settlement. So if there was a carve out by this court, it would be up to FPL to determine whether they wanted to try to negotiate with the parties or to have another rate hearing. But
have you seen any that were not, that actually had some type of severability clause in it?
I have not.
This is more typical where it's all or none.
Again, I can't speak to all of the settlement agreements. I haven't reviewed every settlement agreement.
All right, thank you.
Do you have a position on whether our court has the authority to send it back for an order that actually explains the rationale, as opposed to, we obviously have the authority to reject or approve. Do you dispute that the court has the authority to remand for an order that's actually more sufficient?
Well, I believe 120 does authorize the court to remand a case back to the agency. But in this case, this court has found that the commission has the exclusive responsibility to determine what's in the public interest as it relates to the settlement agreement. Again, I would submit that what appellants are asking is for this court to reweigh, to review what the commission looked at and determine that, in our judgment, we would have ruled otherwise.
Right. No, and I understand that you don't think that that would be an appropriate thing, but as far as just the court's legal authority to send it back for an order that actually goes through and addresses these issues and stuff, your position isn't that we don't have the authority to do that?
I think my position is that the court needs to determine whether there is competent substantial evidence to support the commission's findings. If there's not, then I think that there would be basis to overrule the final order.
And so is the court, so is your position that the PSC can just kind of say, this is in the public interest because, the rates are generally, low compared to the rest of the country, and OPC signs off on it, and, the rate amount, the increase amounts were lowered from what the initial proposal was. And then are we supposed to essentially take that sort of conclusory statement that that's in the public interest, and then we're supposed to kind of comb through the record and just decide, well, if the PSC believed this and if they weighed this and, as being more important than that, then a rational PSC could have decided that that's why it's in the public interest? I mean, that doesn't seem to me like what the administrative process is supposed to be like.
Well, I think in this case, the commission did make some very specific findings as to justify its determination, its ultimate fact finding that it's in the public interest. As you indicated, reduced the base rate $428 million through the settlement process.
Without any kind of finding that the initial request was reasonable. I mean, who cares if it reduces it if the initial request was way out of line, right?
Well, the parties certainly have the ability to put on any testimony to make that point.
But the fact of the reduction in and of itself is meaningless. So I don't mean to argue with you. You have 30 seconds, I'm sorry, to close.
I'm sorry. Thank you, Your Honor. And in closing, the Commission is not required by statute or case law to address each issue of disputed fact. Accordingly, the Commission respectfully requests that this Court affirm the final order. If there are no further questions, thank you.
Chief Justice, and may it please the Court, I'm Daniel Norby from Schutz & Bowen, representing Florida Power and Light Company. Unless the Court would prefer otherwise, I'd like to focus my limited time on two principal areas. First, the Commission's legal authority to approve certain aspects of the settlement challenged by the appellants. And second, whether competent substantial evidence in this large record supports the Commission's finding that the settlement agreement, taken as a whole, establishes rates that are fair, just, and reasonable, and that the agreement is in the public interest.
Mr. Norby, I'm fine with you focusing on those two things, but first, a matter of just agreement. The order itself appears at page 5245 of the record, and it seems to me that all the findings that we're debating here appear between 5264 and 5265. That is 2 pages of the record. Am I right, or are there other findings I should be looking at?
Well, the record from 5252 to 5265 addresses the major issues, the questions of legal authority, and then toward the end of that makes the findings as specifically as to fair, just, reasonable.
All of our judicial review here, all of it hangs on those 2 pages. I mean, are we in agreement that the findings presented to us for judicial review are in those 2 pages?
I'd agree with that. The findings are on those pages. Now, this Court's review, of course, is for competent substantial evidence in the record, not competent substantial findings in the order.
Fair. But to the Chief's question a minute ago, does that mean that our judicial review involves taking these 2 pages of the record and then going through it and doing our own ticking and tying, if you will, supplying our own reasoning to support these findings? Or is it not the PSC's job to do that work for us?
So in the context, Justice, in the context of a settlement agreement, this Court's precedent has said that the PSC must do a few things. It must identify the major issues, and it must provide an answer as to why it is in the public interest and fair, just, and reasonable. Now, the Court is not on its own, I would suggest, in identifying portions of the record supporting the findings. We've outlined, of course, in our briefs and in the Commission's briefs, specific points in the record supporting those findings. If you would like more than that, the post-hearing brief filed by Florida Power and Light in the record at 7971 of the record identifies specific witnesses and specific exhibits supporting aspects of the settlement agreement here. Judges, trial judges, and juries all over the state make findings that certain conduct was reasonable or not. And a reviewing court, when evaluating that finding, that something was reasonable, looks at the record evidence and evaluates exactly what you and what the chief suggested. Whether a reasonable jury, in this case, whether a reasonable commission, could have reached the conclusion it did based on the record evidence that was presented to it. And in this case, the order is supported by a substantial amount of record in this record evidence in this very large record. 60 witnesses, 635 exhibits, more than 80,000 pages, and we've identified in that record specific portions, specific exhibits and witness testimony going to each of those findings in the final order itself. This court, without a dissent in the Sierra Club decision just 4 years ago, addressed what I take to be one of the issues that concerns the court today, the sufficiency of the order here. And this court affirmed a final order that did not address the Peaker project issue that the appellant in that case believed was a major issue. And the final order that was affirmed by this court, again without noted dissent in Sierra Club, was a 3 to 4 page order of the Public Service Commission, as compared to a 21-page order of the Public Service Commission in this case. It's a much more robust order than the order that was affirmed in the Sierra Club case. Now, in this case, there were 140 discrete issues identified in the PSC staff's pre-hearing statement beginning at page 46,191 of the record. And the list of issues in the pre-hearing order, starting at 43,139 of the record, identifies all of those issues and the parties' positions on more than 130 different issues that would have been decided issue by issue with specific findings if this had been a fully adjudicated hearing. This court in Sierra Club said it's unnecessary in the context of a settlement agreement to make specific factual findings as it would be necessary in a fully adjudicated hearing.
Counsel, I'm sorry to interrupt you, and I agree that our court has been complicit in the situation that we find ourselves in now, but can you kind of, as a matter of starting with the statute and first principles, explain why we have even conceptualized this as a true settlement? I mean, really, if there really were a settlement agreement, I don't even know if by all parties, i.e. anyone who would have standing to challenge, we wouldn't even have to be here. So can you explain, from sort of going back to the studs, how this fits within the statutory framework and how it makes sense?
Sure. Well, and part of the answer to that, I think, is that what the PSC does is somewhat different in kind than what a lot of other administrative agencies operating under Chapter 120 do. The PSC, by statute, is a creature of the legislature. Rate making is a legislative function. And so what the PSC does as a legislative function is it engages in the sort of decisions that are generally accorded a lot of deference by this court. It has to fix fair, just, and reasonable rates. Now, under 120.57.4, any proceeding in front of an administrative agency may be disposed of by stipulation or settlement. In that context, the agencies are not required to make the specific findings that they would be required to make under 120.569.
But you don't think, though, as a matter of context and reading it together with 120.569.1, that assumes that all the parties are on board? I mean, isn't that the definition of a settlement? I mean, there's nothing in there that would, I mean, it's kind of a counterintuitive and counter sort of the way things usually operate, to say that you can treat something as a settlement that not everybody in the case is on board with. I mean, and I understand the court has gone along with that, but I mean, are you telling me that textually that's the way 120.57.4 is supposed to be interpreted?
Well, I certainly agree. The court has approved that in Citizens 1 back in 2014 and other places. I think maybe part of the answer to that is that the standards for intervention in administrative proceedings are considerably lower than they would be in an Article 5 court. And this court and the First District Court of Appeal have both held to that principle. There is a lower barrier to entry for a party to get in front of an administrative body and provide their rationale for why it should do one thing as opposed to another. There's not anything specifically in 120.57.4, though, that addresses the issue you've raised. On the public interest factors, which the Commission does outline in its order, final order at pages 20 to 21, all of the public interest factors that this court in Sierra Club and in the Citizens One case back in 2014 have identified as appearing in the Commission's past practice as something in the public interest are in fact found here, and the Commission makes specific findings as to each of them. The overall reasonableness of the resulting rates, rate stability and predictability, the investment in renewable energy, the resulting financial strength of the public utility, its ability to make needed capital investments. Each of those is a specific finding by the Commission in its order, and through our briefing and through our post-hearing briefing below, we've identified specific record evidence supporting each of those public interest findings. I did want to address a question that Justice Polston asked on the question of legal authority to approve various aspects of the settlement. I would agree that that the Commission has no authority to approve something that is contrary to statute. So the Commission's holistic review of the settlement as a whole goes to the non-legal authority aspects of the settlement. So when it's reviewing those other aspects, it does not make, the Commission and then this Court do not make a finding as to individual programs, whether they're prudent, whether they're a good idea. What it does is it looks at them collectively in recognition that a settlement agreement inherently represents compromise and a give and take among the different parties. So it looks at it holistically. On the question of legal authority, I would agree that legal authority is something that this Court reviews de novo, and the Commission here had significant legal authority supporting every one of the mechanisms that it approved in the settlement agreement. I'll start with the RSAM. That was something that had some questions earlier. The Commission's authority to approve the reserve surplus amortization mechanism is part of its general rate-making authority under 366.06. The phrase that my friends on the other side, less accrued depreciation, in the statute that they point to, is simply discussing an entirely different topic than a theoretical depreciation surplus or a theoretical depreciation deficit. What that means, what less accrued depreciation means there, is that once depreciation has been accrued and then you come in at a later point, it can't be collected again. I'd commend the Court to the explanation in the colloquy between Commissioner Graham and FPL witness Robert Barrett at the September 20th hearing, which is in volume 13 of the transcript, record 33,985, for an explanation of how it works. But essentially, to make it in simple terms, a $100 asset that has a projected useful life of 10 years depreciates at $10 per year on a linear basis over the course of those 10 years. So 5 years in, that asset has a $50 value. So less accrued depreciation means that it's valued at 50 as an accounting matter. To a point that Justice Curiel made, if we find out 5 years in that this is actually an asset that would have a projected useful life of 20 years, then that means that there's a depreciation surplus between what's been collected already and what would have been collected had we known at the time, at an earlier time, of what that useful life would be.
Would it be fair to describe the RSAM accounting feature as this is a change in depreciation based upon revised useful life estimates of assets, so that it doesn't change the actual cost that's to be depreciated over time? It's a timing difference. And in this settlement, it's a timing difference that is according to certain parameters that surround it, based upon return on equity and other things. Is that a fair description?
I'd agree that it's a timing difference. And the question then, the question that has to be decided anytime there is a depreciation surplus or deficit is what you do about it. The statute is silent about specifically how that should be addressed. One option is that depreciation surplus could be returned to customers over the remaining life of the underlying asset. This Court in Citizens One addressed specifically the RSAM and approved it against a claim that it would result in unfair rates because it returns this is a quote, returns the excess amounts collected in prior years to customers over a shorter period of time than if the excess depreciation reserve were returned to customers over the remaining lives of the underlying assets, end quote. So what the RSAM allows Florida Power and Light to do over the course of this multi-year settlement is return this depreciation surplus in the form of avoided general base rate increases in years 3 and year 4. So rather than having base rate increases the surplus accounts for that aspect of it. And it's something that's been this accounting mechanism is something that's been used successfully by Florida Power and Light in its 2010, 2012, and 2016 rate settlement agreements here. So it's nothing new, and there's nothing contrary to the statute. The statute is silent on how a depreciation surplus is to be addressed. To a question from Justice Grosshans earlier about the corporate income tax adjustment, and really this statutory authority question goes to multiple mechanisms here, the storm cost recovery mechanism, the solar base rate adjustment. 366.0762 provides the statutory authority for those. The Commission may adopt rules for the determination of rates in a full revenue requirement proceeding, which provide for incremental adjustments in rates for subsequent periods. The rule that the Commission has adopted to implement that, which we've cited in our briefs, also provides that authority. So in the case of all of those mechanisms, the Commission is outlining through this order approving a settlement specific set of conditions, how those things are to be treated if they occur in the future, and in all of them followed up by a true-up type of proceeding at which parties will have an opportunity to examine the numbers to verify that they were, in fact, consistent with the agreement.
Chief, may I ask a question? Thank you. Because you're out of time, but I did want to ask. I mean, the issue, like, for instance, with the corporate tax, I mean, that's would you agree, indefinite, undetermined future rate change that was approved in the settlement, which differs from some of the others, correct?
The specific magnitude of it was not known at the time of the settlement. The specific manner in which it would be treated is outlined in the settlement.
And kind of going to the Chief's question, you see that where our issue is, because we have a statute that says you can approve incremental rate change, which to me means fixed, small. I mean, there's a lot of definitions, but it means something, maybe not indefinite or uncertain. And then we have an order from the Commission that gives us no explanation, no description, no findings, nothing about how that's within the statutory authority to approve something that's completely maybe opposed to the statutory language and has been challenged. And I think that's kind of where we're facing this issue, is we have something very specific that might be an issue, and we have nothing to look at to say, well, what was the rational basis that this was approved under the statute? And I think that's kind of where we're all coming from at this point.
I appreciate the question, and Chief, I do see I'm out of time if I answer. On that question, I think that really is a legal question, and I hope that we've adequately addressed that to the Court's satisfaction in our briefs and in the Commission's brief about why 366.076 does in fact provide sufficient authority to approve this sort of mechanism, as the Commission has done in several prior rate settlements.
And then how about solar together? I mean, in that situation, there's the position on the other side is that it's unduly preferential. There's no analysis in the order whatsoever. It seems like it's at least a legitimate issue. I mean, the PSC's own staff agreed with that when they first looked at it. So in light of the complete absence of any kind of discussion of it, what is the Court supposed to do with that?
So let me address solar together this way. Under the Sierra Club decision, not every issue needs to be discussed. And at the time solar together was being put forward as part of this settlement agreement, it was an important change. But it was a change in magnitude rather than a change in kind from the way that the pre-existing solar together program was structured. And it was the changes that were made in the Solar Together expansion actually made the program overall less preferential in their terms than the pre-existing program. There was an expansion in low-income capacity, an expansion in residential and small business capacity. So what the Commission was considering with Solar Together in the context of this expansion proposed here was not the underlying authority to approve the program, because that had been done in a prior order in 2020 that was not challenged. The Commission was considering simply whether this expansion was fair, just, and reasonable in the public interest. In that context, the absence of specific findings of it make it more similar to the Peaker Project program in Sierra Club than something else, especially in the context of a multi-issue settlement such as this one rather than a single-issue settlement.
Okay, you can have 30 seconds to finish up.
Thank you. Thank you to the Court for your time. The settlement here will allow Florida Power and Light to continue delivering high-quality and reliable electrical service to its customers stable and predictable rates well below the national average. The terms were carefully negotiated to achieve that result against the backdrop of prior commission precedent and against the backdrop of this court's precedent, and they were supported by nearly all of the interveners below from a variety of different customer classes. The commission properly concluded that the settlement was in the public interest and that it results in fair, just, and reasonable rates. Those findings are supported by competent substantial evidence in this record, and this court should affirm. Thank you.
Thank you. With all due respect, it wasn't just a change in magnitude for Solar Together. What happened was it actually made the program more preferential. There was an increase in credits to existing participants, and such that with the expansion, the net transfers that participants are expecting to be paid, it went from $678 million over the life of the program to over $2 billion. Also, as a result of the expansion and the increase in credits to participants, starting in this year, 2023, when the increase in credits went into full effect and the expansion started, participants never contribute to the program in a way that's helpful to the general body of ratepayers. Participants always cost the general body of ratepayers money when you factor in the administrative costs to administer the program for participants. So starting in 2023, this year, the fact that there are participants in the program is going to cost the general body of ratepayers $3.2 million when you include administrative costs. And it only escalates from there. And so when you have...
Were those costs considered by the PSC?
I mean, we certainly made the argument, Your Honor, but as you know...
You did make the argument.
Yes, we made the argument.
That's part of the record, I guess.
Yes, it's in the record, yes, that we include those costs, the transfer, well, all that's in the record. We made those arguments. But as you know, there's only those 2 pages with findings of fact, and none of those findings of fact justify this almost $5 billion rate increase, address the major issues, or explain why this settlement is in the public interest. And I see that I'm out of time, but unless there are any other questions. Thank you.
Thank you again, Your Honors, for the opportunity to address you. I'd like to start by addressing the appellee's argument that the PSC's general rate-making authority allows it to do what it has done here. Both Mr. Norby and Mr. Sunshine agreed that if something's illegal, if it's contrary to the statute, the PSC can't do it. They then try to argue that under the PSC's general rate-making authority, they can do pretty much what they want to do. This very issue was presented to this court in Citizens v. Graham, which we commonly refer to as the Woodford case because it involved a Woodford natural gas exploration activity. In that case, the PSC denied a motion to dismiss, claiming that authority to approve this investment was within its general rate-making authority. When the appeal came to this court, the court reversed, following the standard analysis. You had to determine whether the agency, the PSC in this case, has the statutory authority to do what it wants to do. You determined that it did not have that statutory authority and accordingly reversed. The same is applicable to the RSAM here. With respect to Mr. Norby's arguments, with respect to the RSAM, he agreed that accrued depreciation can't be collected again. The accrued depreciation, the depreciation surplus, is part of the FPL's depreciation reserve. It's a surplus in that amount. The only way the money got there was because customers paid it. By the RSAM, FPL will keep it. They will use it to manage their earnings. You can look in the record. There's the ample evidence as to what they've done over years to maintain their earnings at the very top of their range using RSAM-like features in prior settlements. And once it's applied to their earnings, it is lost to customers forever. This is contrary to law. And with respect to the Deltona argument, in Deltona, the question was whether the PSC could require a certificate of public inconvenience and necessity as part of general authority. There's no general authority, there's no specific authority, and there's no need for the RSAM, no need for the ATAP here. Mr. Norby made my point regarding the ATAP when he said when it comes back to the PSC, if it does, The PSC will review it to determine whether it's consistent with the agreement. That is our complaint. They will review it as to whether it's consistent with the agreement, not as to whether it's consistent with the statutory requirements of 366.06 sub 2 and 366.07. In final summary, Your Honor, Your Honors, thank you very much. FAIR appreciates your consideration of our arguments. We pray that you will reverse the PSC on the two statutory authority claims, and further that you will issue an order finding the PSC departed from the essential requirements of law with remand for further proceedings consistent with that opinion. Thank you very much.
Thank you. We're adjourned for today.
All rise.